Friends, welcome back to my YouTube channel, that is Discourse on Law and Politics. So my dear friends, if you are first on my YouTube channel, please subscribe my channel so you can get such kind of the videos. So now in today's video, we are going to discuss the previous year's papers of UPPCS and today we are going to take the question paper of the year 2012. So we will solve the questions here of the law subject here. So let's start the video. Now the first question which is here, you all can see on the screen, that is, who said that the public policy is a unruly horse? Justice Atkin, Justice Wright, Justice Danny, Justice Barog. Who had said so that the public policy is unruly horse? So this is a question which was already asked in the UPPCS also. Now when we had a UPPCS with subjects in the prelims, at that time they had asked this question. Now they had asked question also in the UP Judiciary in the year of 2012. So what is the answer of this? Now only 3 to 4 days are left to appear in the examination of the UPPCS, which is scheduled on the 12th February. So I hope that you all have completed all the revision. So just check that where you are lacking, how much you have prepared. So we be a part of this journey so that you can access, you can evaluate yourself, and wherever you find yourselves a little bit weak, you can make some improvement as well. So this is how we have these videos for this purpose. Okay. So now what is the answer here? The answer is here, that is Justice Barog had said that the public policy is a unruly horse. Moving to the next question. Under section 182 of the Contract Act 1872, National Textile Corporation Limited is. The options which are given here, whether it would be a government department, or it would be an agent of the central government, or it would not be an agent of central government. An agent of central government if the president consents. Okay. So which is the right answer? So my dear friends, you all know that section 182 of the Contract Act, it talks about the agency. And therefore the question is also here with respect to the agency here. So the right answer here, if the National Textile Corporation Limited will not work as on behalf of the central government, then it is not going to be as an agent. So this National Textile Corporation Limited is not working on behalf of the central government, and therefore it is not an agent of the central government. Moving to the next question, question number 3. Question number says that 3 says that in case of general offer, there is no need to communicate the acceptance if not required by the proposer. This has been held in. So now this question which you can see, it has options. The first one is Carlyle versus Carbolic Smoke Ball Company, Bhagwan Das versus Girdhari Lal, Lal Mansukra versus Gauri Dutt, Ramji Dayal and Sons versus Investment Import. So now here you can see the 4 options are given, and this question is on the general offer. And you all know that on general offer, the Carlyle versus Carbolic Smoke Ball Company is very important case where you need not to give the communication of the acceptance. So the answer is here, this one, Carlyle. The answer is here, that is the Carlyle Carbolic Smoke Ball Company. Moving to the next question. In which of the following cases the Supreme Court held that the section 125 of CRPC was applicable to all irrespective of their religion? So the options which are given here, Muhammad Tajuddin versus Kamruddin Begum, Muhammad Ahmad Khan versus Shah Bano Begum, Teja Singh versus Choto, and Johra Khatun versus Muhammad Ibrahim. So these are the options which are given here. And now give the answer very quickly. Now this is a very important case. It is also important in the maintenance cases also, and this is about section 125 of the CRPC. Now you all know the answer. I know that because of this case, the parliament has brought the another legislation for the maintenance of the Muslim women. So answer is here, Muhammad Ahmad Khan versus Sahabano Begum. Moving to the next question. Question number 5 here. It says that the power to grant anticipatory bail under section 438 of the CRPC, it vests with whom? The options which are given here: the court of magistrate, only in the court of sessions, only in the high courts, and D, both the courts of session and the high courts. Now this is about this anticipatory bail, and from the section 438 of this CRPC. And very important questions in the mains also, some questions are being asked on the anticipatory bail. So just give your answer here. I am looking for your answer and options which you are finding that it is better here, it is the right answer. So just give your answer to the comment box. I am waiting for that. So the answer is both the court of session and the high court. Okay. So moving to the next question. Which one of the following section of the CRPC deals with the High Court's power of revision? The options which are given here: section 395, section 401, section 399, section 396. So which is the right answer? The right answer is here, section 401 of the CRPC. It talks about the revision. Moving to the next question. The judges of family court cannot be considered for elevation as high court judges. This is the question. The judges of the family court can't be considered for elevation as the high court judges. Now the Supreme Court has held this in which case? The options which are given here: Sanjay Agrawal versus Union of India, TGN Kumar versus State of Kerala, Viswajit Majhi versus State of Uttarakhand, and the last option, that is SD Joshi versus High Court of Judicature at Bombay. So which is the right answer here? Just give me your answer immediately through the chat box. I'm waiting for your response here. The right answer is here, that is this one, that is the TGN Kumar versus State of Kerala. In this case, the Supreme Court held that the family judges of the family courts, they can't be considered for the high court. Moving to the next question. The Constitution Scheduled Tribes Order Amendment Bill 2011 is related to which state? See, my dear friend, this question which had been asked, it is with respect to the year of 2011. And the question paper which we are solving here, it is of the 2012. So you can find that there is also nexus that you all need to know the recent amendment bills also, so that you can get all the questions from there. So therefore, please remember all these things, because this kind of the contemporary question, this kind of the you can say that the question which are recent news in the respect to the bill and all this, they may be asked. So the options which are here: the Madhya Pradesh, Andhra Pradesh, Arunachal Pradesh, Assam. So which is the right answer? If you have any idea of this, then fine. Otherwise, I am giving the answer here because it is of like current affairs. So the answer is here, Arunachal Pradesh. Moving to the next question. The next question is, what is the name of bill which has been passed by both the House of Parliament with respect to the cable television, with regard to cable television? So again, this is a kind of the law, this is the kind of question which is related to the year of 2011. You all can see all the bills are belonging to the year of 2011, and the question paper which we are solving, it is of the 2012. So there is a nexus between the recent bills and the question papers which are going to come. So the options which are given here: the Cable Television Network Regulation Amendment Bill, the Cable Network Amendment Bill 2011, the Cable Television Regulation Amendment Bill 2011, the Cable Television Network Bill 2011. So which is the right answer? Just give your answer through the comment box. I am waiting for your answer. However, I know that you have this kind of limitation, that it is a kind of the question which is belonging to the the current affairs. So I am giving the answer quickly here. That is the A option. The Cable Television Network Regulation Amendment Bill 2011 was the question, was the answer of this question. Okay. Moving to the next question. Under the Code of CPC, that under the Code of Civil Procedure 1908, an appeal may be filed by way of what? How can you file an appeal under the CPC? So the options which are given here, that is application, petition, memorandum, or the notice. So just give your answer here immediately. I am waiting for your response, please. So the appeal can be filed by the memorandum under the CPC here. Okay, moving to the next question. Which of the following provision is related with set off under this CPC? Order 5 rule, Order 8 rule 5, Order 8 rule 6, Order 7 rule 5, Order 7 rule 6. So under which provision of the CPC it is about this set off? So just give your answer immediately. I am waiting for your response. It is a very popular question, and the answer is here, Order 6 rule 6, Order 8 rule 6. So this is the right answer here. Moving to the next question. The Human Rights Council is a subsidiary organ of General Assembly, subsidiary organ of Economic and Social Council, subcommittee of Human Rights Commission, Committee of Security Council. So Human Rights Council is a subsidiary body of which kind of the body among this? So the answer is here, this is the answer, that it is subsidiary organ of Economic and Social Council. So this is the right answer. Moving to the next question, that is the International Criminal Court. International Criminal Court consists of how many judges? The first option, 18 judges. Second is 15 judges. C is 9 judges. And D is 17 judges. So the International Criminal Court consists of how many judges? So this is a very popular question, and this kind of a question had been asked so many times in the competitive examinations, also of the UPPCS and the civil services earlier. So the right answer is here, that is the 15 judges. Moving to the next question, which is here, law is uncertain and certainty of law is a legal myth. Who has made this statement? The options which are given here, Jerome Frank, Holmes, Gray, and Levlin. Who had said that the law is uncertain and certainty of law is a legal myth? So just give your answer. So the right answer is here, the Jerome Frank had said this one. Now we are skipping this question number 15 here, you all can see, because this question is more related to the year of 2011, and it is like the questions from the current affairs on the international matters. So this is how we are skipping the questions. However, for the sake of no answer, I am just giving you answer here. That is the when it was the climate talk was held in the South Africa, and when it was renewed the Kyoto Protocol and concluded, on which date it was happened. That was the date of the December 11, 2011. December 11, 2011. This was the right answer. Moving to the next question here. Which one of the following is not the prerequisite of presumption as to dowry death under section 113B of the Indian Evidence Act? So which is not the prerequisites for the presumption of dowry death? The first option, victim was subject to cruelty or harassment by her husband or relatives. Victim had illicit relation with other male person. Such cruelty or harassment was for connection with any demand for dowry. It was done within the 7 years of the marriage. So, my dear friends, you all know that this is a very important question from the Indian Evidence Act under Section 113B of the Indian Evidence Act. So, if you just see the options which are given here, the right answer is here this one B. Victim had illicit relations with other male. So, this is not a factor which is in contributing for the dowry death. Moving to the next question. The next question is here. One of the most important principles of the law of evidence is that evidence is to be weighed and not to be counted. So this has been incorporated under which section of the Indian Evidence Act of 1872? So the options which are given here, the Article 132, Article 133, Article 123, Article 134. So these are the options which are given here. And now give your answer immediately to the comment box. Which is the right answer here? Any one of you, please. Waiting for your response. So the answer is here, section 134. Okay. Moving to the next question. According to whom the matter of jurisprudence is a positive law, simply and strictly so called, or law set by political superior to political inferiors? Who had said so? Now the options which are given here, you all can see the Allen, Austin, Buckland, Bentham. So these are the four options which you all can see here. So who had said so? So just give your answer. The right answer is here. That is the Austin. Austin had said so. Moving to the next question. The principal jurist of the philosophical school was? Who was the principal jurist of the philosophical school? So the options which are given here, Herbert Spencer, Sir Henry Maine, Max Weber, Hegel. So which is the right answer? Just give your answer to the comment box. I am waiting for your response here. So the right answer is here. That is the Hegel. Moving to the next question. Which one of the following is not kind of an agriculture lease? So which is not a kind of agriculture lease? This is a question which was also asked in the Bihar Judicial Service also. So the options which are given here, the first one is lease for cultivation of indigo, lease for cultivation of vegetables, lease for rearing tea plants, lease for gathering fruits from trees. So these are the four options which are given here, which is not a lease. So just give your answer here. So the right answer is here, lease for gathering fruits from trees. So this is the right answer. Okay. Moving to the next question. Every sale accompanied by agreement for conveyance of property would not constitute mortgage by conditional sale. This statement is related to which section of the Transfer of Property Act? So every sale accompanied by agreement for reconveyance of property would not constitute mortgage by conditional sale, which this statement relate to which section of the TPA? So the options which are given here, section 55, section 56, section 60, section 58. So give your answer here immediately through the chat box. So the option is here, 58 is correct, section 58. Moving to the next question. Who of the following author is said as father of English jurisprudence? So the options which are given here, let's see here: Austin, Bentham, Salmond, Roscoe Pound. So who is the father of English jurisprudence? The answer is here Austin. So this is the right answer. Moving to the next question, and the question is: reasonable time for the performance of a contract is a question of fact, law, prudence, or fact and law. So which is the right answer? Fact, law, prudence, or the fact and law? So the right answer is here. The question is of the fact. So A is the correct answer. Okay. So this is how you can find here. So this is the correct answer. Moving to the next question. The question is here: the Indian Constitution is dedicated to whom? The options which are given here: the first one, the Constituent Assembly; the second is the Parliament; and the third is the whole society. The last one is the people of India. So the whole society, or the people of India, or the Constituent Assembly. So the right answer is here the people of India. So this is the right answer. Moving to the next question. Which constitutional amendment introduced the anti-defection provision of the Constitution? And the options which are given here: the first 51 amendment, 52nd amendment, 53rd amendment, 54th amendment. So through which amendment the anti-defection law was brought to the Constitution? So this is the question which you all can see. So the right answer is here the 52 amendments, and the 52nd amendment of the Constitution is the right answer. Moving to the next question. Which one of the following does not come within the territorial jurisdiction of Punjab and Haryana High Court? The options which are given here: Punjab, Haryana, Chandigarh, Delhi. So the question I am repeating again: which one of the following does not come within the territorial jurisdiction of the Punjab and Haryana High Court? So the right answer is here Delhi. Okay, so this is the right answer. Moving to the next question. An agreement in restraint of trade under Section 27 of the Indian Contract Act of 1872 is valid, void, voidable, or enforceable. So you can see it is with respect to the Section 27 of the Indian Contract Act. Now in this case, an agreement in restraint of trade is going to be void here. Okay. Moving to the next question, and it is with respect to communication here. A proposes by letter to sell a house to B at certain price. The communication of proposal is complete when A posts the letter, A has completed the writing of letter. The third option is here: B gets information about the posting of the letter, B receives the letter. So this is how you can find. These are the four options which are given here. So now let's see, and now give me the answer to the chat box. I am waiting for your response here. The option is here when B receives the letter. Okay. Now moving to the next question. A and B enter into a contract due to mistake that the particular debt is time barred. A and B enter into contract due to mistake that a particular debt is time barred. The contract is whether it would be valid one, illegal, void, both B and C. Just give an answer. Waiting for your response. The right answer is here. It would be a valid one. Okay. Valid one. Moving to the next question. A contract of telephone becomes complete at the place where acceptance is heard. It was held in which case? The options which are given here: Bhagwan Das versus Girdhari Lal, Carlyle versus Carbolic Smoke Ball Company, Mohri Bibi versus Dharmo Das Ghosh. The last option is Satyabrat Ghosh versus Mugni Ram. So which is the right answer here? So the right answer of this question is here. That is the Bhagwan Das versus Girdhari Lal. Okay. Now moving to the next question. A wagering agreement depends on an uncertain event, future event only, past uncertain only, and none of the above events. So a wagering agreement depends on which kind of incident? Just give your answer immediately here. So the option is here, which is correct, that is uncertain event. So this is the right answer, an uncertain event. Moving to the next question. The question which is here, which one of the following is not essential for a contract? The options which are given here: consideration, valuable consideration, lawful consideration, and the adequate consideration. So which is the right answer here? So the right answer is here, the valuable consideration is not essential for the contract. So it is not essential for the contract. Okay. Moving to the next question. Continuing guarantee. Continuing guarantee has been defined under which section of the Indian Contract Act? Section 124, Section 129, Section 146, or the last option, that is Section 147. So which is the right answer? Just give your answer to the comment box. The right answer is here, that is the Section 129 of the Indian Contract Act. Moving to the next question. The interpretation clause of the Indian Contract Act 1872 has been provided in which section of the Indian Contract Act? It is very easy answer. You all know the answer. This Section 1, Section 2, Section 3, or D, under none of the above. So the right answer is here. You all know that is the Section 2. Section 2 of this Indian Contract Act, it has a provision with respect to the interpretation clause. Okay. Moving to the next question. An agreement to do an act impossible in itself is unenforceable, whether it would be the unenforceable, voidable, wrongful, void. So just give your answer quickly to the comment box, waiting for your response here. So the right answer is here, it is going to be void. Moving to the next question. A promises to obtain for B an employment in the public service, and B promises to pay rupees 1000 to A. The agreement is whether it is legal, can be enforced at the option of the parties, void, or none of the above. So here in this case, you can see A makes a promise. A promises to obtain for B an employment in the public services, and B also promises to pay rupees 1000. So if A says that I will give a job, and B in that make a promise that yes, I will pay 1000 rupees, then that is going to be very illegal, and therefore it would be a case of the void agreement. Moving to the next question, and this question is about the state the correct answer. So we have to see the correct answer. Okay. If object of an agreement is forbidden by law, the agreement is void only but not illegal. Illegal only but not void. Both void as well as illegal, and the last option, that is voidable. So just give your answer immediately and quickly. So the option is here, right? Both void as well as illegal. Moving to the next question. The question is here, the word illegal is applicable to everything which is an offense, is prohibited by law, furnishes ground for civil action, or all of the above. So which is the right answer here? Which is the right answer? So the right answer is here all the above. Okay, because in all these cases you have a right to say that it is as illegal. Okay, moving to the next question. What is necessary to constitute an offense of criminal conspiracy? Two or more person, five or more person, agreement to cause illegal act or any by illegal means. If act is not crime, to do some act in pursuance of agreement. So the question is here, what is not necessary to constitute an offense of criminal conspiracy? So you all know that in the conspiracy there must be more than one person, then five or more person, which is given here. Minimum person must be always two here, so it is not necessary that you must have a minimum person as a five. So this is the not is necessary to constitute an offense. So this is the right answer. Moving to the next question. A, knowing that her husband B has committed murder, knowingly conceals in order to screen him from legal punishment. A is liable. So A is knowing that her husband has committed some crimes, and now she is giving some kind of the harboring. She conceals her. So this is how it is there. So whether she has committed an offense. So the options which are given, whether murder by reason of having common intention, harboring, abatement by aid, A has committed no offense. So if a wife harboring or conceals his husband, whether it would be an offense. So now as per the IPC, it would not be the offense. So therefore A has committed no offense. Okay, so this is the right answer. Moving to the next question. Before coming, I need to remove this one. Yes. Okay. Moving to the next question. Which section of Indian Penal Code deals with the dowry death? You all can see the options which are given: section 304B, 364A, section 363A, section 366B. Okay. So what is the right answer? Just give your answer very quickly. I am waiting for a response. So the answer is section 304B. Okay. So this is the right answer. Moving to the next question. A and B plan to murder C. The next day they are guilty of the offense of planning, the offense of criminal conspiracy, the offense of attempting to murder, or no offense. Okay. So just give your answer immediately here. I am waiting for a response. So here they are planning to murder C, and then when more than one person, yani A and B, that means both are more than two person, then in that case it would be a case of the criminal conspiracy here. So this is the right answer. Okay. Moving to the next question. Which offense does not require a minimum number of 5 persons? Okay. So the options which are given here: unlawful assembly, riot, robbery, dacoity. So in which kind of the offense there need not to have minimum number as a 5 persons. So just give your answer here immediately. I am waiting for your response here. Which is the right answer? The right answer is here. Just give your answer. The right answer is here, robbery. Moving to the next question. Which one of the following is a continuing offense? Which one of the following is a continuing offense? The options which are given here: abduction, rape, theft, abatement. So which is the kind of offense which is like a continuing offense? So you will see it means the offense will be continued till its no application. That is how you can see. So this is going to be here in the case of abduction. It would be a continuing offense. Moving to the next question. Under section 362 of the Indian Penal Code, the offense of abduction may be committed with a girl under 18 years of age, a boy under 16 years of age, a person of unsound mind, and D, none of the above is correct. So just give your answer quickly through the chat box. I am waiting for your response here, my dear friends. So the right answer of this question is none of the above. Okay, moving to the next question. A police officer without warrant apprehends Z, who has committed murder. A has committed the offense of wrongful confinement, wrongful restraint, C, A and B both, or D, none of the above. So which is the right answer? Just tell me. So this offense would be the wrongful confinement. Moving to the next question. In every statute, mens rea is to be implied unless the contrary is shown. The options which are given here: Shiraz versus D. Rudgen, R versus Dudley and Stephen, Harding versus Price, R versus Prince. So mens rea is implied in the statute unless the contrary is proved, and this was said in the case of Shiraz versus D. Rudgen. Moving to the next question. The question is this: A in India instigate B, a foreigner in Pakistan, to commit a murder in Pakistan. B commits murder in this case. So whether A is guilty of abetting murder, A is not guilty of any offense, A is liable for committing murder, and D, none of the above. So which is the right answer here? Just give me answer. So my dear friends, you can see the answer is here: A is guilty of the abetting murder. So this is the right answer. Moving to the next question, and it is about the matching. So we have to see which is not correctly matched. Okay, so let's see the question. Mens rea is with R versus Prince. It is correct. Insanity is a case of McNaughton. This is also correctly matched. Intoxication is very much correctly matched with the case of Basudev versus State of Pepsu. And the necessity, which is here, it is not the case of DPP versus Bayer. So the right option, which is not correctly matched here, is this one: necessity, DPP versus Bayer. Moving to the next question. A commits theft on property in B's possession, and while committing theft, he has loaded pistol under his garment, kept for the purpose of hurting B in case B resists. So now in this case you can see A commits theft on property in B's possession, and he has a loaded pistol in case if any kind of the things happens when B resists, then he can hurt B also. So which kind of the offense is going to be done by A here? So let's see the options which are given here. Under which section? Section 382, section 379, and the next option is section 390, section 381. So my dear friends, give the answer immediately. Which section will apply here? So the right option is section 382. So this is the right answer. Moving to the next question. The question which is here: the principle of proximity of crime under criminal law is irrelevant when deciding the liability for the offense of. Okay. The options which are given here: theft and dacoity, culpable homicide and murder, kidnapping and abduction, abatement and conspiracy. So the right answer which is here of this question, that the principle of proximity of crime will not apply while deciding the liability for the offense, and the case is abatement and the conspiracy. it is itself sufficient. Once you did abatement and conspiracy, it is not necessary that you need to prove whether actual offense has been done or committed or not. Moving to the next question. Theft is an offense against the options which are given here: a person, movable property, both movable and immovable property. So the right answer of this question is here, that is, it is for the movable property. Okay, so this is the right answer. Moving to the next question. A married a a married man commits the offense of adultery if he has sexual intercourse with A. So a married man commits the offense of adultery if he has sexual intercourse with the unmarried woman, married woman except his wife. The third option is here: any woman except his wife, unmarried woman without her consent. So this is an offense of adultery. So obviously it would be against a married woman, but that woman should not be the wife of that man. So the option B is going to be correct. So this option B is correct here. Moving to the next question. This question is here: A puts jewels into a box belonging to B with the intention that they may be found in that box, with the result that B may be convicted for the offense of theft. So A has committed the offense under, so the options which are given here: Section 191 of the Indian Penal Code, Section 192 of the Indian Penal Code, Section 193 of the Indian Penal Code, and D, A has committed no offense. So just give your answer immediately here. Which option is correct here? So A will be guilty of this section 192 of the Indian Penal Code. Okay. So this is going to be the right answer here. Okay. Moving to the next question. X drives very fast through a crowded road to catch a flight, knowing that his act in all probability may cause death. Y is killed by his vehicle. X is guilty of culpable homicide amounting to not murder. The second option, murder. The third is grievous hurt. And D, the negligence. Which is the right option? Just give your answer to the comment box. I am waiting for a response here. So my dear friends, it would be the offense of murder, because he knows this fact that in all probability it may cause a death. So he knows about that, and therefore he would be the guilty of murder here. Moving to the next question. Which section of the Indian Penal Code deals with the voluntary intoxication? So the options which are given here: section 84, section 85, 86, 87. So which is the right answer here? Just give your answer to the comment box. I am waiting for a response. So my dear friend, the right answer is here, section 86. Moving to the next question. When the Rio Declaration on Environment and Development was made. So the options which are given here: June 1992, December 1989, June 97, and the last option is here, September 2002. So which is the right answer? So this is important question also. Rio Declaration was made in the June 1992. So this is the right answer. Option A is the right answer. Moving to the next question. And now this question is, here you can see, it is with an incident which took place in the year of 2011. So it is like an international current affairs, and I am skipping this question here because this question is not going to be asked in the examination. But With this case, you can get an idea that the questions are also coming from the international current affairs in the category of international law here. Moving to the next question, Copenhagen Accord on climate change is whether it is a binding treaty, not binding treaty, and the next option is here. Next option is a declaration of General Assembly, and the last one an optional protocol. So the right answer of this question is right option of this question is here. This is one. It is not a binding treaty. Okay. Moving to the next question. Under which section of the CRPC the offense has been defined? So the options which are given here, section 40, section 2N, section 2W, and the last option, that is none of the above. So just give your answer immediately through the comment box. I am waiting for a response here. Please share your answers here. And the right answer here is section 2N has a definition with respect to the offense. Okay, moving to the next question. Now this question is again with respect to the one international current affairs that was happened in the year of 2011. So this is how you can find that. So you all need to remember that there may be some question which may be asked from the current affairs. So we are not taking these questions because this question will has no probability to come in the examinations. Moving to the next question. Under which provision of the CPC the collector may be appointed as a receiver? So under which provision of CPC the collector may be appointed as a receiver? The options which are given here: Order 40 Rule 5, Order 41 Rule 1, Order 40 Rule 2, Order 41 Rule 5. Okay, so which is the right option? Give your answer through comment box. I am waiting for a response here, my dear friends. The answer is this: Order 40 Rule 5. So this is the correct answer. Moving to the next question. The question is this: a receiver is the options which are given here: officer of the court, agent of the plaintiff, agent of the defendant, agent of the parties to the suits. So just give your answer here. I am waiting for a response. The right answer is here: the receiver would be an officer of the court. Moving to the next question. Which one of the following case related to dying declaration? The options which are given here: Mehboob Shah versus King Emperor, Queen versus Abdullah, Kotaya versus King Emperor, and MC Varghese versus Ponan. Which case is related to dying declaration? So this question is on this section 32 of the Indian Evidence Act. So just give your answer to the comment box. I am waiting for your response here. So the right answer of this question is here: Queen versus Abdullah. So this is the right answer. Okay. So the right answer is here: Queen versus Abdullah. Moving to the next question. This is the question here. Next. To what facts of the following the rules of relevancy have been discussed under section 8 of the Indian Evidence Act? Now the options which are given here: the motive, preparation, previous or subsequent conduct, and D, all of the above. So we have to answer to what facts of the following the rule of relevancy has been discussed in section 8 of the Indian Evidence Act. So just give your answer through comment box. I am waiting for a response here. So the right option is here: all of the above. Moving to the next question. Which of the following statement is incorrect? So we have to see which is incorrect under Transfer of Property Act. The first option is here: right of redemption belongs to mortgagee, right of foreclosure belongs to mortgager, right of redemption can be abrogated, and right of foreclosure can be abrogated. So just give your answer immediately to the comment box. I am waiting for a response here. So the right answer of this question is here: right of redemption can be abrogated. So this is the right answer. Moving to the next question. Which of the following is not an essential element of a gift? The options which are given: donor and donee, subject matter, transfer of subject matter, transfer must be for consideration. So these are the options which are given here. Now just give the answer immediately through the comment box. I am waiting for a response. The right answer is here: transfer must be for consideration. So this is not an essential element. It is not an essential element of the gift. Moving to the next question. And the question is this: for the lease of immovable property, the tenure for more than 1 year or year to year, that the attestation of notary is sufficient. It is valid if the execution of it is made before the magistrate only. It is sufficient if the parties made an agreement. Only registration is sufficient. So for the lease of immovable property, and the tenure is from year to year. So from year to year, if you are looking for the lease of immovable property, then which condition from this is going to be applied? So that is the question which is here. So now give the answer immediately here to the comment box. I am waiting for your response here. So the right answer of this question is here: only registration is sufficient. Okay, so this is the correct answer. Moving to the next question. The word secular used in the preamble of the Constitution of India means. The options which are given here: the state has no religion of its own, all religions are treated equally, the state has no common religion, and the last option, that is both A and B. The answer of this question is very easy, so please give your answer. I am waiting for your response to the chat box. So my dear friend, the option of this one is both A and B are correct. So this is the right answer. Moving to the next question. It is about the 12th schedule. Okay. So the 12th schedule was added to the Constitution by which amendment to the Constitution it was added? The options which are given here with respect to 12th schedule: the 74th Amendment, 73rd Amendment, 65th Amendment, 44th Amendment. So what is the answer here? Just give your answer through chat box and comment box. So the right answer is here: 74th Amendment of the Constitution. This is the right answer. Moving to the next question. The 44th Constitutional Amendment 1978 was amended Article 32, deleted Article 31 and introduced Article 300A, deleted Article 32 from Part 3rd of the Constitution, introduced a new Article 300 in the Constitution. So the right option of this question is here: it deleted Article 31 and introduced Article 300A. So this is the right answer. Moving to the next question. The question is this: in Re Berubari and exchange of enclaves, the Supreme Court held. So this is a case with respect to in Re Berubari. So the options which are given here, the Supreme Court held, the options is that like this: rule of law is not a part of Constitution, rule of law is a part of the Constitution, preamble is not a part of Constitution, preamble is a part of the Constitution. So just give your answer to the comment box. I am waiting for a response here, my dear friends. So the right answer of this question is here: preamble is not a part of the Constitution. So this is the right answer. Moving to the next question. How many types of writs can the Supreme Court issue for the enforcement of fundamental rights? So, how many types of writs can be issued by the Supreme Court for the enforcement of fundamental rights? The options which are given here, the 6, 4, 5, and 3. And the answer of this question is this here, that is the 5. There are 5 writs which you can use for the enforcement of the fundamental right. Moving to the next question. State executive power is vested with whom? The options which are given here, Chief Minister, Council of Ministers, Chief Minister and Council of Ministers, and the last option is the Governor. So which is the right answer here? Just give your answer to the comment box. So the right answer of this question is here, that is the Governor. Governor is the right answer. Moving to the next question. Prime Minister itself is a separate class. This was laid down in which case? Ram Prasad versus State of Bihar, R.K. Garg versus Union of India, State of MP versus G.C. Mandewar, P.V. Sastry versus Union of India. So just give your answer to the comment box. I am waiting for your response here. So the right option of this question is here. That is P.V. Sastry versus Union of India. So this is the right answer. Moving to the next question here. The question is here, who can constitute the State Administrative Tribunal under the Administrative Tribunal Act 1985? The options which are given here, the President of India, Supreme Court, Parliament, concerned state government. Now give the answer immediately to the comment box. I am waiting for a response here. And the answer of this question is here, the President of India. Moving to the next question. Under which article of the UN Charter the Security Council has the power to use force against a state? The options which are given here, Article 41, Article 2, Clause 4, Article 24, Article 42. So just give your answer immediately here. I am waiting for your response here, my dear friends. So the right answer is here, Article 42. The right answer is here, Article 42. So that the UN, the Security Council, they can use the power against the state. Moving to the next question. The judgment of International Court of Justice is to be signed by. Who will sign on the judgment? The options which are given here, the President of the court, the Registrar of the court, all judges who heard the case, the President and the Registrar of the court. So just give your answer immediately through the chat box. I am a comment box. I am waiting for a response. So the right answer of this question is here, this, the President and the Registrar of the court. This is the right answer. Moving to the next question. The question is this, consider the following statements. International law is not law at all. International law has no judicial system to enforce the law by applying sanction. And the options which are given here from this above, only A is true, only 2 is true, both A and 2 are true, both A and 2 are not true. Of course, international law is a law and they have a judicial system like International Court of Justice, and therefore there is no question that they don't have any judicial system. So therefore the answer which is going to be here, it is this one, that is both B and both 1 and 2 are not true. Both 1 and 2 are not true. Okay, moving to the next question. Which one of the following is not a case relating to doctrine of precedent? And the options which are given here, Sajjan Singh versus State of Rajasthan, Prakash Chandra Pathak versus State of UP, Leversis versus Anderson, Bengal Immunity Company Limited versus State of Bihar. So we have to give the answer that which case do not belong to the doctrine of precedent. Okay, not a case of doctrine of precedent, that is we need to locate here. Now the options which are given, just give me answer immediately here. I'm waiting for a response. So the right answer of this question is Leversis versus Anderson. This case do not belong to the doctrine of precedent. So this is not the case. The rest of the case they belong to the doctrine of precedent. Okay. Moving to the next question. Which one of the following schools of legal thought held the view that law is found, not made? It is self-existent. So which school of law says that law is found, not made, and it is self-existence? The options which are given here, you can see historical school, analytical school, and the next option is here sociological school and realistic school. So the school which says that the law is found not and it is self-existent, then the option is historical school. So right answer of this question is historical school here. Okay. Moving to the next question. In which of the following cases the Supreme Court overruled its own precedent for the first time? And the options which are given here: the Kharak Singh versus State of UP, Menka Gandhi versus Union of India, third Bengal Immunity Company versus State of Bihar, the fourth one Keshav Mill Company versus Income Tax Commissioner. So in which case the Supreme Court overruled its own precedent for the first time? So just give your answer immediately through the comment box, chat box. I am waiting for a response here. The answer is here, this Bengal Immunity Company versus State of Bihar. Moving to the next question. Who said this? Law is what the judges declares. This statement relates to which of the following? So we have to see who is the person who said so. And the options which are given here: Jerome Frank, Julius Stone, Gray, Holmes. So now give the answer here. I am waiting for a response here, please. And the right answer of this question is here, my dear friend, that is Gray. So this is the correct answer. Moving to the next question. Who described jurisprudence as lawyer's extraversion? The options which are given here: Savini, Salmond, Julius Stone, and Buckland. So we have to see who had said so, lawyer's extraversion. So the options which is correct here, that is the Julius Stone. And you know that this is very important questions. It has been asked in many times in the UPPCS as well. Moving to the next question. The law means the entire body of rules in a state, a particular law, the rules of morality, the rules of natural justice. So my dear friends, give the answer to the comment box. I am waiting for your response here. See, the right answer of this question is here, this one, the entire body of rules in a state. So this is the right answer. Moving to the next question. Movement of progressive societies have hitherto been from status to contract. Who had said so? That the movement of progressive society is from status to contract. And the options which are given here: Bentham, Roscoe Pound, Henry Mann, and Savini. So my dear friends, give the answer here. I am waiting for your response here. So the right answer of this question is Henry Mann. Moving to the next question. Legal right is an interest recognized by law, protected by law. Both A and B are correct, and none of the above. So just give the answer very fast in the comment box and chat box. I am waiting for a response here. Legal right is an interest. Which is correct? So my dear friends, the answer which is correct here, both A and B. The legal right must be recognized by law and it must be also protected by the law. Moving to the next question. The question is this: on which date the Statute of International Criminal Court has come into force? So on which date this came into force? And the options which are given here: 10th December 2003, 24th October 2002, and the next option is here. Next option is this: 1st July 2002 and 1st January 2003. So which is the right answer here? Just give your answer immediately. The right answer of this question is the Statute of International Criminal Court came into existence on this. That is the 1st July 2002. So this is the correct answer. Moving to the next question. Where the UNESCO headquarters is situated? And the options which are given here, that is Geneva, London, New York, and Paris. Okay. So just give your answer immediately. I am waiting for your response here. The right answer of this question is the office of UNESCO is in the Paris. Moving to the next question, and this question which you all can see, it is with respect to the recent, that means the international current affairs. So we are not going to take this question because this question will not come in examination. But you can see, you all need to see all the international development which is taking place between the states, so that a question may come if in examination you can answer to this one. Moving to the next question also, you also can see this question is here, is also about the recent development which took place in the year of 2011. And we are solving the question of the year of 2012. So obviously the question which is going to be asked from the current affairs, it would be from 2011. So again, we are not going to take this question. We are skipping this question here. Moving to the next question. This question is also based on the current affairs, and the question which is here, SCO Cup Summit was held in which country? And this kind of a question may come, but it may come with a new recent years. It is not like 2006. However, for your information, I just want to tell you it was happened in this Shanghai. Okay. And moving to the next question here. And this is also another case which is based on the international affairs. And the question which is here, which tribunal or court has put Lubanga of Congo on trial? The options which are given here: International Court of Justice, Tribunal for Yugoslavia, Rwanda Tribunal, and International Criminal Court. So you can see this one, and the answer of this question is here, International Criminal Court. Moving to the next question, and this is a question from the CPC. What it says: which provision of the CPC temporary injunctions are granted? Under which provisions the temporary injunction provision is given? And the options which are given here: section 116, section 152, order 39 rule 1, order 29 rule 1. So give the answer immediately to the comment box. I am waiting for a response here. So the right answer of this question is here, my dear friends. It is order 39 rule 1. Okay. Moving to the next question. The question is this: who can file a suit under section 91 of CPC for public nuisance. And the options which are given here: advocate general, any citizen, district magistrate, any 10 or more citizens. Now give your answer to the comment box. I am waiting for a response here. And my dear friends, the answer of this question is here advocate general. Moving to the next question. The duration of existence of a caveat filed under the CPC of 1908 is, it is for 60 days from the date on which it was filed. It is for 30 days from the date on which it was lodged, 120 days from the date when it was lodged, 90 days from the date when it was lodged. So give your answer immediately to the comment box. I am looking for your answers here. And the right answer of this question is here 90 days. Okay. Moving to the next question. Deemed decree implies whether it is final judgment of the court, final order of the court, first para of the judgment, last para of judgment till decree is prepared. So just give your answer immediately to the comment box and chat box. I am waiting for your response here, my dear friends. And the correct option of this question is final order of the court. So this is the correct answer. Moving to the next question. The question is this: in the matter of kidnapping and rape, the evidence given by prosecutrix being illiterate and rustic young women, some contradictions and omissions are natural as her recollection, memory, observance and narration of chains of events. It was held by Supreme Court in case of the options which are given here: Manoj Yadav versus Pushpa, State of UP versus Chote Lal Yadav, Madhu Verma versus Urmila Devi, Lakhan Lal versus State of Bihar. So my dear friends, give the answer immediately to the chat box and comment box. I am giving the answer here. The right answer of this question is here State of UP versus Chote Lal. Moving to the next question. Which one of the following is not actionable claim? And the options which are given here, you can see a claim for means profit, a claim for area of rent, a share in partnership, a claim for return of earnest money. So now give your answer immediately through the comment box. I am waiting for your response here. So my dear friend, the right answer is here a claim for the means profit. Okay. Moving to the next question. The next question is this: on proclamation of emergency under Article 352, the President has power to suspend the fundamental right except the right secured by. And the options which are given here. And the option of this question, that when during the proclamation of emergency, certain fundamental rights is not going to suspend it. And the options which are given here: Article 19 and 20, Article 20 and 21, Article 20 and 22, Article 19, 20 and 21. So which is the right answer? Just give your answer immediately. It is very popular question. I know that you all know the answer and I am waiting for a response. The right answer of this question is Article 20 and 21. So this is the right answer here. Moving to the next question. The concept of Austin's sovereignty is influenced by the ideology of which of the following person? So the Austin sovereignty concept was inspired by which person? The options which are given here: Hobbes, Locke, Rousseau, Montesquieu. And the right answer of this question is here, my dear friends, Hobbes. The right answer is this, Hobbes, not the Rousseau here. So I'm just giving the right answer here, Hobbes. Okay. Moving to the next question. The state is the synthesis of family and civil society. It is the unity of the universal principle of family and the particular principle of civil society. The above philosophy was given. So who had said this? That the state is like a synthesis of family and civil society, and it is the unity of universal principle of family and particular principle of civil society. So who had said so? The options which are given here: Hegel, Roscoe Pound, Austin, and Savigny. So just give your answer immediately. I am waiting for your response here. The man who had said so, the name was Hegel. Moving to the next question. So the question which is here, which of the following theories relating to legal rights has been propounded by hearing? That means among these theories, which was propounded by the hearing on the legal rights? Okay, let's see the options here. The options which are given here: will theory, concession theory, realist theory, interest theory. And the right answer of this question is here, this one, that is the interest theory. Moving to the next question. And the question is this: which of the following are correct combination? Bentham and natural law, Austin and positivism, Roscoe Pound and sociological school of jurisprudence, Henry Mann and philosophical school of jurisprudence. And the options which are given here: 1 and 2, 2 and 3, 3 and 4, 1, 2 and 3. So the right answer and the right option which is correct, which are correctly matched here, this one, 2 and 3. Austin belongs to positivism, Roscoe belongs to the sociological schools, but this man who is Bentham, he do not belong to the natural law school, and this man Henry Mann belongs to the historical school. So therefore this answer is the correct here. Okay, moving to the next question. Which one of the following is not a mode of acquisition of possession? And the options which are given here: taking, delivery, and the next option which is here, that is by operation of law and by acquisition. So the right answer of this question is here, that is by the acquisition. So this is the right answer. Okay, moving to the next question. So the next question which is here, that is, custom is society, what law is to the state? So now who has said this, that custom is to society, what law is to the state? And the options which are given in this question: Dias, Salmond, Lloyd, Finch. So who was the man, or who was the jurist, or who was the legal philosopher who had said this thing, that is, the custom is to society what law is to the state? So just give your answer immediately through a comment. I am waiting for your response here. Yes, please. So the option which is given here, among these options, the Salmond has said. So this answer is correct. Now coming to the next question. Which of the following is not a specialized agency of the United Nations? And the options which are given here: Universal Postal Union, United Nations Children's Fund, International Civil Aviation Organization, International Finance Corporation. So these are the options which are given here. And now let me know which is the right answer through your comment box and chat box. And the right answer of this question is here, which is given here. Just give, is this. Why? Because it says the United Nations Children's Fund. This is not, it is not like a UNICEF. So this is the answer. Okay, so don't confuse it with the UNICEF. So how many the next question is that the powers and futures of United Nations are divided among how many principal organs? So this is the question, and the answer is very easy. I know that you all know the answer, so just give the answer immediately. So options which are given 5, 4, 7, 6, and the right answer of this question is this one, that is the D. So this is the right answer. Okay, moving to the next question. The real power of appointment of the United General lies where? Security Council, General Assembly and the Security Council, the 5 permanent members of the Security Council. So just give your answer. So the question is here, where the real power of appointment of UN Secretary lies, whether it is in Security General, it is in General Assembly, or it is in General Assembly and the Security Council, the 5 permanent members of the Security Council. So give your answer here. I am waiting for your response here. The answer of this question is, because it is about the real power, you can see here. This is the real power. It is about the real power. Therefore, the real power rests in the General Assembly and the Security Council. In case if any member of the Security Council it use the power of veto, then in that case it is not possible to appoint someone as a Secretary General of the UN. Now the next question, who was the Indian candidate for the post of Secretary General of the United Nations? So you all know the answer. Indian candidate for the Secretary General, and the answer is very simple, that is Shashi Tharoor. Okay. Moving to the next question. International law also develops through state practices, and it is being called as international treaty, international committee, international customary law, international morality. So international law develops also through the state practices, it is known as. So just give the answer. The answer of this one, international customary law. Okay, moving to the next question. Rule of state succession was first incorporated from the Roman law by whom? The options which are given here, Bentham, Kelson, Oppenheim and Grotius. So rule of state succession was incorporated from the Roman law by whom? Just give your answer here. The right answer is here, the Grotius. Moving to the next question. The question which we are having here, to preserve one's life is generally speaking a duty, but it may be the highest duty to sacrifice it. This observation was made in Queen versus Dudley and Stephanie by which judge? So the options which are given here, that is the Lord Denman, Lord Coleridge, Lord Acton, Justice Pollock. So the right answer is here, that is the Lord Coleridge. He was a judge of this case and he has given this statement, that is to preserve one's life is generally speaking a duty, but it may be the highest duty to sacrifice it. So this is the statement which was made by the judge here. Coming to the next one. Question. Which one of the following is not an illustration of criminal force? The options which are given here, A split over B, A removes the wheel of a lady, B causing annoyance to her, A removes the wheel of lady B causing annoyance to her, A shakes his feet at B, and the D, A pours boiling water in the bucket from which B was bathing. And this is very important question, and this kind of question has been already asked in so many times. So give me the answer here. I am waiting for your response here. So the right answer is here, A shakes his fist at B. So this is the way you can find the answer of this question. Moving to the next question. The next question which is here, that is, which of the following is an offense against body, property, reputation and feelings under the Indian Penal Code of 1860? So we have to see which offense is against body as well, property as well, reputation as well as feeling here. We have to see. Okay. And the options which are given here: kidnapping, abduction, rape, cheating. So which is an offense which covers all these offenses against body, property, reputation and feelings? So just give your answer to the chat box and comments. I am waiting for a response here. And the right answer is here, cheating. Moving to the next question. Assault in order to outrage the modesty of women is punishable under which section of the IPC? So the options which are given here: under section 363 of the Indian Penal Code, section 509 of IPC, section 511 of the IPC, section 354 of the IPC. So just give your answer to the comment box. And the right answer of this question is under section 354 of the IPC. Moving to the next question. Law is not universal in nature like language, it varies with the people and ages. This proposition follow from the theory of which? So it says that the law is not universal, it is like language and it varies from people to and ages. And the options which are given here: the social utilitarianism, vogue-gist, social solidarity, social engineering. So these are the options which is given here. You can see. And which is the right answer? Just give your answer through comments. And the right answer is here, the vogue-gist. Moving to the next question. The next question says, judges not only discover law, but also they made the law. Who was the man who said so? Okay. So the options which are given here: the Gray, Dicey, Samant and Blackstone. So the right answer of this question is here, that is the Blackstone. Blackstone had said so. Now coming to the next question, dealing with the sources of law, who among us the following was said that the courts fuel life into the dead words of a statute? Who had said so? And the options which are given here: Holland, Gray, Salmond, Austin. The statement which is here, that is, who had said that the court only fuel life into the dead words of a statute? Okay. So the right answer of this question is here, Austin. Austin had said so. Moving to the next question. The period of limitation within which defendant shall submit his written statement. The options which are given: 30 days from service of summons, 40 days from service of summons, 60 days from service of summons, 120 days from the service of summons. So just give your answer from the chat box, comment box. I am waiting for a response here. The right answer which you can see is here, 120 days from service of summons. Moving to the next question. Judgment under section 29 of the CPC 1908 means a decree, a dismissal of appeal summarily, a statement of grounds of an order or decree, or D, all of the above. So which is the right answer here from here? Just tell me which is the right answer. Either it is decree, dismissal of appeal or summarily, statement of grounds of an order or decree, or all of the above. Give me your answer quickly here. And the right answer of this question is here, all the above. Okay. Moving to the next question. It says this: section 115 of the CPC provides provision for what? for reference, review, revision, appeal to the Supreme Court. You all know the answer. Just give your answer to the comment box. I am waiting for your response. So section 115 of the CPC, it talks about which kind of the provisions. And the right answer of this question is here. It is about the revision. So this option is correct. Moving to the next question. Here, no right of action is conferred on a transfer in possession under an unregistered contract of sale. Which section of the TPA contains this principle? The options which are here: section 35, 41, section 53 of the TPA, section 53A. Just give your answer through the comment box. I am waiting for a response here. So the question is this: no right of action is conferred in transfer in possession under an unregistered contract of sale. Which section says this? The right answer of this question is 53A. So this is the right answer. Moving to the next question. The amendment of the Transfer of Property Act 1882 in the year 2002 amended the provision of which section of the TPA? The options which are given here: section 100, section 106, section 108, section 110. So which is the right answer? Just give your answer through the comment box, chat box. And the right answer is this, section 106. Moving to the next question. Which property cannot be transferred? And the options which are given here: a public office, a mere chance to succeed, a mere right of re-entry, and D, all of the above. So just give your answer through the comment box. So which property cannot be transferred? That all these things can't be transferred, and therefore the right answer is all of the above. So this is the right answer. Moving to the next question. The power of judicial review in India is possessed by whom? And the options which are given here: Supreme Court alone, by all courts, Supreme Court as well as the High Courts, and none of the courts. So just give your answer to the comment box. I am repeating the question again here. The power of judicial review in India is possessed by which court? Okay, so just give your answer to the comment box. And the right answer of this question is Supreme Court as well as the High Court. So this is the right answer. Moving to the next question. The next question is: Rajya Sabha can withhold money bill for a period of 14 days, 3 months, 6 months, or none of the above. So which is the right answer? The right answer is 14 days. So a money bill can't be more than 14 days in a Rajya Sabha. Okay. Moving to the next question. Reservation of seats in educational institution in favor of scheduled caste and scheduled tribes is governed by which article of the Constitution? Article 15 clause 4, Article 16 clause 4 of the Constitution, Article 29 clause 2 of the Constitution, Article 14 of the Constitution. So just give your answer through comment box. I am waiting for your answers. And the right answer of this question is here, Article 15 clause 4. Okay. Moving to the next question. The next question is: Loya Jigra is the term used for tribal council which will have a decisive role in framing of new constitution of which country? So Loya Jirga is a body which belongs to the Afghanistan, and therefore the answer of this question is Afghanistan. Moving to the next question here. The next question is here: which country became independent in the year of 2000 after 450 years of Portuguese rules, followed by a quarter century of Indonesian occupation? And the options which are given here is Timor, Nauru, Andorra, Kiribati. So which country became independent in 2002 after 450 years of Portuguese rules? And the answer is here is Timor. Moving to the next question. My dear friend, this is a question which is from the current affairs of the international law. So we are skipping this one here. Okay. Moving to the next question. The rule enunciated by Section 65 of Indian Contract Act 1872 is applicable to agreements which are discovered wired by the options which are given here: mistake, failure of consideration, impossibility, or all of the above. So Section 65 of Indian Contract Act, it talks about it applicable to which kind of the agreements. So just give your answer to the comment box. I am waiting for your response here. And the right answer of this question is here, the impossibility. Moving to the next question. A contract of life insurance, the performance of which depends upon a future event, falls under the category of which kind of the contract? Contingent contract, contract of indemnity, contract of guarantee, or special contract. So which is the right answer? Give your answer to comment box. So the LIC is on the future action, and therefore it would be the contingent contract. So this is the right answer. Next question. Which of the following statements regarding consideration is not correct? Okay. The first one is it must be given at the desire of the promiser. Second, it may be passed also. It need not be adequate to the promise, and stranger to it cannot sue. So which of the statement which are given here is not correct, we have to see. Okay. So this statement which is here, stranger to it cannot see, is not correct, because in some cases the Indian Contract Act allows. Moving to the next question. Which one of the following is not an organ of the United Nations? So we have to see not an organ of United Nations. And the options which are given here: Economic and Social Council, International Court of Justice, Trusteeship Council, World Health Organization. And the right answer of this question is here, the World Health Organization. Moving to the next question. Who can request the International Court of Justice to give an advisory opinion on any legal question? And the options which are here: any member of United Nations, the highest court of justice of any nation, the General Assembly of the United Nations, any permanent member of the Security Council. So who can seek the advisory opinion? Just give your answer here. I am waiting for a response. Yes, the answer is this, C, the General Assembly of the United Nations. So this is the right answer. Moving to the next question. Which of the following state has rejoined UNESCO? Has rejoined the UNESCO on October 1st, 2003 after 19 years. So which was the country which has rejoined after 19 years? And the options which are given here: USA, India, Sweden, France. So which is the right answer here? Give your answer to the comment box, and you will be surprised to know the name of this country. And the name of this country is United Nations. So this is the right answer here. Okay. Moving to the next question. Which of the following is not a specialized agency of the United Nations? Which is not a specialized agency of the United Nations? And the options which are given here: you can see International Bank for Reconstruction and Development Bank, Food and Agriculture Organization, UN Human Rights Commissions, International Labour Organizations. So which is the right answer? Just give your answer to comment box. The right answer is UN Human Rights Commission. UN Human Rights Commission is not a specialized agency. Okay. Moving to the next question. The 6th conference of World Trade Organization was held in December 2005. At where? Although this is a contemporary question, or you can say current affairs, but just for the sake of your I am giving the answer here to this question. The answer is Hong Kong. Okay. However, this is not likely to be asked because it is a international current affairs. Again, when was an Indian Airlines plane on its flight from Kathmandu to Delhi hijacked and taken to Kandahar by terrorists? So when it was happened, so just give the answer here. So options which are given here: the September 1989, December 1999, September 2001, July 1994, and you all know that the year is this one, December 1999. So this is the right answer. Moving to the next question. Total, the European Union now includes total number of members. That is, so the answer is here 27. To the next question. The CPC code will not applicable to which kind of the matters? Civil matters, revenue matters, service matters, land law and local laws. So just give your answer here. I am waiting for your response here. So where CPC code will not apply, in which kind of the matters? And the right answer of this question is here. That is the service matter. So in service matter, it is not going to apply. Moving to the next question. Which one of the following is directive principle of state policy? And the options which are here: right to education, right to property, right to move Supreme Court, right to organize village panchayat. And the right answer is here, that is to organize the village panchayat. Moving to the next question. Which one of the following is correct statement? In deciding the question as to disqualification of member of parliament, the president shall act. So the options which are given here: according to the opinion of the election commission, according to the opinion of the Supreme Court, with the aid and advice of the Council of Ministers, and last, in his own discretion. And the right answer is this: according to the opinion of the election commission. Okay, so this is the right answer. Moving to the next question. Under section 14 of the Indian Evidence Act, which of the following facts become relevant? Namely, the options which are given: facts showing state of mind, facts showing state of body, facts showing state of bodily feelings, and D, all of the above. So section 14 of the Indian Evidence Act, it becomes relevant in what matters? The answer is this, the all of the above. So this all are relevant. Now next question is here. Who said this? Some shared morality is essential. Some shared morality is essential to the existence of any society. Who said this statement? And the options which are given here: Jeremy Bentham, Austin, Fuller, Hart. It is about the some shared morality, and the answer which is going to be given here, that is the Fuller. Fuller had said so. Moving to the next question. Even a student may be treated as an expert under section 45 of the Indian Evidence Act. It was laid down in which case? The options which are given here: Bhogni Bhai Hira Bhai versus state of Gujarat, Sankaria versus state of Rajasthan, and the next option is Kanpur University versus Samir Gupta, Punjab Singh versus state of Haryana. And the answer is this question is Kanpur University versus Samir Gupta. Moving to the next question. What is the meaning of rescission of the contract? What is the meaning of rescission of the contract? How to understand? And the options which are given here: the renewal of original contract, cancellation of contract, alteration of contract, substitution of new contract in place of earlier one. Okay, so just give me the answer immediately, because this is going to the second last question of this revision. And the answer of this question is here, the cancellation of the contract. Okay, so this is the right answer. Coming to the last question. What is the position of contract when it is being caused by mistake of law? Okay, and the options which are given here: voidable, not voidable, void, illegal. So just give me the answer of this question. And now, my dear friends, if you are first on my YouTube channel, please subscribe this channel so that you can get more such videos. So thank you for watching this video. But before giving the thanking you again, I need to give the answer to this question. Please give your answers in the comment box, and now I am going to give the answer from my side. What will happen in case of a contract happens when it was done by the mistake of law? The answer of this question is here. It would not be voidable. Okay. So this is the right answer. Okay. So with this, friends, we are finishing the question paper of the UPPCS PCS 2012 PCSJ. I am writing again. We are finishing the question paper of UPPCS J of 2012 of law subject prelims. So please subscribe my channel for more such video, and thank you for watching this. We will meet with another video. Thank you.